Welcome to this session on overseas data transfers. In this Business 101, we're going to have a look at the privacy issues and the practical steps to take when you're transferring data overseas. So, as far as the law goes, there are some rules, especially in Europe, that govern when you can transfer data overseas. So in the UK, this is governed by the Data Protection Act 1998, and in Europe, it's governed by the Data Protection Directive 1995, which has been enacted into various jurisdictions through primary legislation, like the Data Protection Act 1998. In this session, we're also going to explore as well the General Data Protection Regulation, which is going to come into force in May 2018. So, if we have a look now at outsourcing, one of the most common ways which data is transferred overseas, we're just going to consider some of the ways in which you might actually transfer data overseas without even being aware of it. So commonly when it comes to outsourcing, you might decide to use service providers who give you maybe IT or email services, or a myriad of other reasons, such as fulfilling contracts and even contracting with the likes of Amazon. So when you're outsourcing, what do you need to look for? Well, you may not look for anything at all, especially if you're buying software so-called off the shelf, where you just click and buy it through a website. But you need to pay attention to those terms and those licenses, and not just click through and say, I accept, because they contain very important terms about how data is lawfully transferred overseas, as well as many other things, such as that company's liability if you have a data breach, or perhaps even they just fail to provide their services. So do pay attention to those. So what does the law require when you're outsourcing with regards to data protection? Well, it requires that you enter into a written contract guaranteeing that the supplier will put in place appropriate security measures. So they are technical and organisational measures that make sure that data is kept nice and safe. So the reasons for that could be, say, for instance, in case data gets hacked. So you might have seen in the news hacks by groups who attacked really large organisations like TalkTalk or that dating site Ashley Madison and revealed all of the details of those people who've been registered on that site. And your outsourced service provider also has to act on your instructions. Well, what does that mean? Basically, it means that they only transfer data and use it for purposes which you've determined. So do have a look in your terms, and if it says things like, we might use the data for our own business purposes, do take care. So what else might you want to do though above and beyond what the current law requires? Well, you'll want to make sure that the supplier deletes the data when the contract is over, so that they're not using perhaps your contact data about your clientele for their own business purposes. And you'll also want to look at restricting their subcontracting. Why would you want to do this? Well, if you think about it, I might ask you to process something for me, to do a task. We'll say put stamps onto envelopes, and I'm willing to pay you £10 an hour to do that. But you realise that there's a way that you can actually get it done for £2 an hour. Say, maybe in the Philippines or India, it only costs £2 to put stamps on envelopes. Well, you might decide that actually it's better to do it that way as my contractor, so that you take the £8 profit and only have to pay £2. But I might not be happy with that subcontracting, and I might want to restrict that. Well, in the simple example of envelopes, it's difficult to see how there might be problems there. But if you put this into the context of modern business and things like email addresses or banking details or other important information that you hold about your clients, you're going to want to know that that subcontractor is actually giving all of the care and the attention to that data that you've asked your contractor to provide. So making sure that it's safe and that it's secure and that you know that they're not going to do anything with it that you wouldn't be happy with. And all of the things that prevent data breaches happening, which can lead to reputational damage, cost to you, and maybe loss of your customers. And that leads me on now to the next issue. You really want to think well about how to impose liability on your contractors. So that basically means that if you suffer a breach, and maybe if a client sues you, or if something happens to information, and as a result of that you suffer a business loss, or maybe you have to instruct lawyers or take remediation measures such as setting up a call hotlines to deal with angry customers, you can pass that liability for all those costs onto your contractor. So do have a look at the liability provisions in these standard contracts And if you're deciding to enter into the contract on your standard terms, perhaps, have a look and see if you've got liability provisions in there to keep your company protected. Similarly, if you're on the other side of the fence and you're actually the supplier, have a look and see if there's anything such as a wide-ranging indemnity. And basically an indemnity means that you're liable for all losses at a very simplistic level. So have a look at that and see maybe if there are caps in there too. So it might say that you're liable up to £500,000, for instance, for breaches of data protection or in the contract more generally. It's very important to have a look at those terms and see if you're comfortable with them and if you'd want to change them or make them different. And as well, going back to that subcontracting point there, just the third section down, you also want to make sure that your contractor is liable for the acts of their subcontractor, because otherwise you may end up with no ability to recover losses from a subcontractor who's the ultimate cause of a breach of the contract, and you just can't pursue them because you don't know who they are, or perhaps they don't have enough money to make it worth suing them. So you want to make sure that whoever you're shaking your hands on that deal with, or entering into that email conversation with, or whoever's getting to sign that piece of paper with you, is the person who you can deal with in the event of a breach. So we've just explored outsourcing more generally there. And although this is a video on overseas transfers, it's important that we look at those points so that you understand how contracting basically works and where you're probably most likely to be looking out for these points. In your day-to-day business activity, if you do have, say, group companies within your business and you're dotted around all over the world, it's going to be really important to think about overseas transfers. So say if you have sister companies in Switzerland, maybe one in Canada and maybe one in India, they'll all have different processing restrictions attached to them, as well as looking at when you actually go outside your organisation and outsource your service provisions. So now we're going to have a look at overseas transfers in a bit more depth. So what are the requirements? At a very basic level, as you can see from this slide, whenever personal data travels across borders, the data controller, and that's the organisation that determines the manner and the purpose of the processing of the personal data, has to ensure that the personal data remains secure at all times. So what this means in essentials is all of the protections that would be afforded to data in the European Economic Area because of the legislation we discussed at the start of this tutorial, so the Data Protection Directive and the General Data Protection Regulation when in force, give certain securities and standards in relation to data. So you can process data in the European Economic Area without restriction because through the laws that we have, we know there's an adequate level of protection. But we can't know that for the countries outside the European Economic Area. So when the data is transferred across borders, we have to make sure there's some sort of security in place. And what that's referred to in European law terms and in the various legislation enacted in different jurisdictions in Europe is that there has to be a level of adequacy with regards to data security that must be complied with. So what does that mean in practice? Well, it can be achieved through a variety of methods depending on the type of the data transferred. So say, for instance, if it's just email addresses and names, or perhaps more security measures are required if we're transferring sensitive information, so health information, criminal convictions information. And you have to put in a transfer mechanism that would be appropriate for the type of transfer. So there are a few different measures through which you can do that, and we're going to have a look at those now. So firstly, let's have a look at model clauses. So these are available under the current European law regimes, and they will be available under the General Data Protection Regulation. But do watch out because they might be updated in a few years' time. So it's always worth just having a think about that and looking at the European Commission website. So why do we have model clauses, and why are they good in your business context? Well, they're approved by the European Commission as having that finding of adequacy. And they mean that when you enter into them, the data exporter, so that would be your organisation, and the data importer, so perhaps your overseas entity or your outsourced service provider, are making sure that there's protections there with regards to the data that's transferred. And it allows individuals, referred to in legal terms as data subjects, to have a right of recourse if something happens to their data and they need to make a claim against those transferring entities. So that's basically what the model clauses do. They put in place this bridge, this secure bridge, which allows you to transfer data. And if that data subject, that individual, needs to travel over that bridge to find a way to get recourse for some action that they're not happy about or something that's happened to their data, they can do that. So they have this bridging effect. Why would you use them in your business? Well, they're very easy to implement. As we said, they're a standard document. They've received a rubber stamp of adequacy from the European Commission. So you don't need to do any drafting. You don't need to pay anybody to get them in place. You can simply go and print them off, enter into them. You fill in a schedule at the back which deals with data security issues, and very merrily you can go about your way transferring data then. So there's very limited cost with them. I also like to use them personally when I'm dealing with data transfers, because I find that they're just a good way to make sure that you do have that adequacy in place. Because as you'll see as we go through the slides and through this tutorial, not every measure actually has a finding of adequacy quite as good as these approved rubber stamped clauses. So these are just a very nice way to make sure that you've got a safe transfer mechanism in place. So if you want to get a copy of these documents, we do actually have them available via our website on DATATHENA.com. I would recommend that you do go get the copy we've provided there, because the version that's available via the Commission website is in a PDF and isn't quite as friendly to input the details that you need to in the security schedules, as well as your details too. So you'd end up in a position where you might need to write them in pen, which isn't ideal if you need to get different parties to have a look over them. So I would say use that Word version that we've made available, because it just looks a bit more like a standard document, and you can amend it and you can save a copy and you can use it for numerous transfers then, and fill out the details that you need to, and then have your own precedent document so that you don't need to be replicating things every time. So we're going to have a look at some other transfer mechanisms now. So a second one that's available for US to UK transfers and vice versa is the Privacy Shield. Now this is a self-certifying scheme. What does self-certification mean? Well, it means that organisations in the US sign up to the Shield and they say that they meet these findings of adequacy in relation to transfers. They declare that to the Federal Trade Commission in the US, and then on the Government Department of Export website for the USA, it says that these organisations have certified that they're meeting the security measures that they need to. So you may have noticed there's a bit of a difference in terms of who's determining the process flow. So with the model clauses, the European Commission have decided what's adequate. With the Privacy Shield, the organisation itself decides what's adequate. So for a UK audience in particular and a European one, it might feel a bit strange to say that you're relying on someone's self-certification standards. But it's important to remember that the way that US law works is more principles-based, and that if you don't comply, there are fines associated with it, and the risk of the fines act as the stick to make sure that organisations comply. But again, as you can see, the model clauses feel like a slightly better option because they go wider and they encompass different types of transfers. These clauses have been available from August 2016, and the reason that I point that out is that this self-certification scheme was originally a different scheme, and this is really a 2.0 of the original scheme called the Safe Harbour, which was invalidated by a European court case in relation to transfers, as it was deemed that the Safe Harbour wasn't providing a valid mechanism to transfer data. At the time of this recording, I would say just exercise some caution with the Privacy Shield, because it is being challenged at the moment in the lower European courts by a group called Digital Rights Ireland. And with the change of government in the USA, be aware too that there might be some changes as a result of some of the changes to privacy legislation and surveillance bills that could impact on the primacy of the privacy shield. So again, I think that's another good reason why you might want to look more towards the model clauses. And now we have bespoke contracts. The clue's in the title here with them. Bespoke by nature means that they don't have a finding of adequacy. So they are useful where you really want to set out the obligations that apply as between the organisations transferring the data. But as I've just said there, they are not automatically deemed adequate. So you can't say that they have that rubber stamp from the Commission saying that it's fine to use them. When would you want to use these then, bearing in mind those limitations? Well, you might want to use them for intra-group transfers, complex agreements, and positions where you have very heavily negotiated liability provisions. So this is really more suitable for very complex contracts and transactions, and not really just for the day-to-day humdrum of data transfers. You can enter into them, but you do just have to be aware, of those limitations, and you may also need to file them with relevant local authorities, and they may have to check to see if they think that they're adequate too. So there might be an extra level of procedure there that's associated with the use of the bespoke contract. And now we have binding corporate rules, which sounds terribly grand, doesn't it? Now, these can apply to intra-group transfers, where you have lots of companies within the same group, dotted all over the world. And they can also apply to transfers to certain suppliers. They are for routine, large-scale transfers. So you really have to assess the cost and benefit of putting them in place. Essentially, they set out a level of principles that say what an organisation can and can't do with data. These need to be submitted to your supervisory authority. So say, for instance, in the UK, the Information Commissioner, who, if you are a primarily UK-based business with or companies elsewhere around the world that aren't your main organisation, would need to go to the Information Commissioner in the UK as lead authority to have them checked. And then they're sent to other authorities who may wish to comment on the draft. So say, for instance, if you were based in Germany, it would also go to the regulators in France and Germany. So there can be a lot of procedure associated with getting binding corporate rules to a final form. You also have to have a look at all of the policies that you have in place with your organisation and conduct data audits so that you can really explain to those authorities how data is flowing within your organisation. So again, unless there's a need to really commit to the route of binding corporate rules, it's something that is really more for complex transfers. So do bear that in mind when considering your options for overseas data transfers. So that summarises how you can transfer data overseas. If there are any questions that you have that you don't feel have been answered in this session, please do feel free to drop them below and we'll answer them in an upcoming Q&A. We have regular Q&As on a weekly basis when we look at all of the updates happening in privacy law, so just pop that question down and we'll always do our best to answer it. If you want to have a look at the impact of the General Data Protection Regulation in particular, because there's lots of other obligations coming out of that, do have a look at DATATHENA.com. And if you want those free model clauses we talked about as well, go there too. They're freely available to download. Once you've got them, you can use them straight away. And if you want to have details of any of our other services, why not check out our videos for more tips, tricks and policies. And don't forget to sign up to our weekly newsletter by clicking the link below.